Associate Justice Hugo Black of the Supreme Court has been called the court's philosopher. In this interview with CBS News correspondents Eric Severide and Martin Agronsky, the first ever held with a justice of the Supreme Court, Justice Black discusses the possible conflict between constitutional law and morality, freedom of speech, and police powers versus the rights of the accused.
Mr. Justice, you've dedicated your life in many ways on the court toward the application of the Bill of Rights to all of the states. Now, you said once, it's my belief that there are absolutes in our Bill of Rights, and that they were put there on purpose by men who knew what words meant, and meant their prohibitions to be absolutes. What are your reasons for saying that?
Well, I'll read you the part of the First Amendment caused me to say there are absolutes in our Bill of Rights. I did not say that our entire Bill of Rights is an absolute. I said there are absolutes in our Bill of Rights. Now, if a man were to say this to me out on the street, Congress shall make no law respecting an establishment of religion. That's the First Amendment. I would think, amen, Congress should pass no law, unless they just didn't know the meaning of words. That's what they mean to me. Certainly they mean that literally, and I see no reason to attribute any less meaning than they would have had then or would have now. They might not have that meaning now because of the general idea that there can be no absolute anywhere. I don't agree to that. They wanted to mark boundaries because there were some things they did not want government ever to have the power to do. There were some things they didn't feel that way about. They felt that they should have power to do it within what they call reasonable limits. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Now, I assume if they had wanted to make all searches and seizures illegal so that no government at all could ever have a search and seizure, they would have said so. But they said unreasonable. And you turn on down to Amendment 8. It says excessive bail shall not be required. It says excessive. And the people who wrote it knew that it did not set specific boundaries. I subscribe to the doctrine that the Fifth Amendment, which says that no person shall be compelled to be a witness against himself, means that no person shall be compelled to be a witness against himself. Now, the theory that's opposite to mine has been the fact that that's bad and it's unlawful, the Constitution prevents it, is not because it's in the Fifth Amendment. Well, if it's not because it's in the Fifth Amendment, where does it come from? Is it the mind of the judge? In other words, is he going to fix limits to the Constitution? I don't see that. I don't think I have that power, and I wouldn't do it. That's why I don't claim any right to keep the Constitution up to date. I've sustained laws as constitutional that I was bitterly against. Didn't believe in them.
But you felt it was your obligation to sustain them because they were constitutional, despite what your conscience
I think it's my
dictated.
obligation to take this Constitution. I don't care what anybody else has decided. That's immaterial. Our system of government puts different people on the court, people with different views. I think it's their business to try to read these words, as silly as it may sound to some people. Some people have said that I'm either a knave or a fool, because if I was not dishonest, I couldn't say that they are absolutes. Well, I just don't agree with them. I think I can and do.
Mr. Justice, I would think you'd know the Constitution by heart at this time. Why do you always carry that little book of the Constitution?
But I don't know it by heart. I can't, my memory is not that good. when I say something about it, I want to quote it precisely. And so I use it, carry it in my pocket.
Do you think, Mr. Justice, that most Americans understand the Constitution?
No, I think most of them do not. I think most of them are sure they do, better than the court. People don't know it, but they think they know it. And their idea is all the same. You can trace it to the same thing and make a difference what it is, what their experience is, or why they're mad with the court. It's all because each one of them believes that the Constitution prohibits that which they think should be prohibited and permits that which they think should be permitted.
Mr. Justice, you raised the point that sometimes a judge could be too legalistic, too concerned with the legal approach. Now, suppose you were to find in some case which you were considering that there was a difference between what you thought was fair, what the heart says and what the law provides. How would you decide?
Well, I would follow what I thought the law provided, undoubtedly. Just there. That's it. You see, you have laws written out. That's the object in law, is to have it written out, our Constitution. I would follow exactly what I thought it said at the time, and I wouldn't try to amend it, because I thoroughly believe in the division of the three branches of government.
Would you ever reach beyond the law? Do judges ever do that?
Undoubtedly they do. There was one basic thing about the desire for the Bill of Rights. One great urge was that a great many people believed in natural law, the natural law concept. Some of them put it on a religious basis, some put it on a philosophical basis. The natural law concept, that is what's fair, what's best, what in some people's language today is the most decent way to follow a custom and a government. And so someone conceived the idea that due process of law meant according to fairness, decency. And they began to write to that effect. Of course, it's been my idea that that's not what it meant, because that would do something that I'm not for, and I do not believe the Constitution provides. That is, it would permit the judicial branch of government, which is supposed only to interpret the Constitution and the law, to write it from day to day, and month to month, and year to year, what best fits the times. Now, that's a very prevalent philosophy. I'm not sure, but what it's the controlling philosophy in this government, as far as lawyers are concerned, as far as government is concerned.
You don't feel that the judges should judge according to what fits the times?
No. How would they know? Jefferson asked if, says the others want to trust just one man, and one man can certainly not sense what's right and just any better than the whole public.
There was one historic shift by the court that seems to relate to this point. In 1898 in Plessy-Ferguson, the court held that separate could be equal in interstate transportation. Yet in 1954 in Brown versus the School Board, it held that separate could not be equal in school education. Now, the law hadn't changed. What appears to have changed is the judge's opinion of how the law should be interpreted. In other words, did they not relate to the temper of the times?
The judges had changed. That's right. The judges had changed. As far as my opinion is concerned, my agreement to that case, I would have agreed to it in Plessy and Ferguson. I would have agreed to it at the time those amendments were first adopted. And that's my view was that we had a simple question. Does that give to the colored people of the nation equal protection of the law? Now that means, well, they're being treated any better because you gave them different schools and separated them. And if so, was it, as those Civil War amendments provided, given on account of race? Well, I've lived in the South all my life, practically, until I came up here. And of course, I knew what it was. I didn't need any philosophy or any changing times to convince me that that was a denial of equal protection of the law. And I never, for one moment, based my decision on anything except I thought it was a denial of equal protection of the law then, had been in the past, and will be in the future.
When the segregation decision was handed down, Brown versus the School Board in 1954, there was one clause included in the Chief Justice's majority opinion in which he referred to the implementation of that decision with all deliberate speed. What effect do you think that particular reservation has had?
Looking back at it now, it seems to me that it's delayed the process of outlawing segregation. It seems to me probably, with all due deference to the opinion and my brethren, all of them, that it would have been better, maybe, I don't say positive, not to have that sentence, to treat that case as an ordinary lawsuit and force that judgment on the counties it affected that minute. That's true that that would have only been one school. And each case would have been only one case. But that fitted into my ideas of the court not making policies for the nation.
Mr. Justice, if I could turn a minute to the workings of the Supreme Court. The court gets, I think, around 2,500 cases sent up there every year, and you can take under consideration only about 10% of those. Ought there be fewer cases sent up, or ought there be more justices? Is this a case of justice denied because it's delayed?
I don't think it can fairly be said that we give no consideration to all who apply. I think we do. You can't decide the case, can't write long opinions, but when we meet, we take up the cases that are on our docket that have been brought up since we adjourned. Frequently, I'll mark up at the top, denied, not of sufficient importance. No dispute among the circuits, or something else. And I'll go in and vote to deny it. Well, I've considered it to that extent. And every judge does that same thing in that conference. So that when you take up all the cases that are denied this year or any year, the court did, to some extent, consider them.
Does the Chief Justice have any extra power that other justices don't have in the court?
No power. Somebody has to have power to run the court, decide about what he'll say at first. That means that there are certain cases that, so far as he is concerned, he would not argue at all. He thinks they're too simple.
But his power really among his colleagues is simply limited by his persuasive power.
His persuasive, I would say, as everywhere else practically, it's limited only by his integrity, his strength of character, his wisdom, the knowledge of his wisdom.
Justice Black, on this matter of free speech and assembly and the rights of people to have order, and I think you wrote a dissent a couple of years ago, involved a small public library in Louisiana, and you said that no group, however just their cause, has a constitutional right to use other people's property, even the property of government,
Right,
as a stage to express their dissent.
yeah.
If protesters or demonstrators can't use, don't have any inherent right to use streets or public places, aren't you really infringing the right of protest itself? How can they do it? Where do they do it?
Well, that assumes that the only way to protest anything is to go and do it on the streets. That is not true. That is just simply not true in life. It never has been true. We've had a government where people have been protesting against one another, having elections, having different religions, meeting at different places, having different parties, meeting at different places, all through history. But we haven't had to say, and I've never said, that the freedom of speech gives people a right to tramp up and down the streets by the thousands, either saying things that threaten others with real literal language, or that threaten them because of the circumstances under which they do. I've never said it. Bill Douglas and I both expressed our view on that about 25 years ago, in which we said that the First Amendment protects speech, and it protects writing, and it protects assembly. But it doesn't have anything that protects a man's right to walk around and around and around my house if he wants to, fasten my people, my family up into the house, make them afraid to go out of doors, afraid of something will happen. It just doesn't do that. That's conduct. These fellows, when they wrote an absolute, now if they had written and tried to say that Congress should pass no law regulating conduct, then I would have said, the terrible thing is it can't regulate any conduct. It doesn't say that. It says you shall not pass a law involving freedom of speech of the press. And that's talk. The Constitution doesn't say that any man shall have a right to say anything he wishes, anywhere he wants to go. That's agreed, isn't it? Nothing in that says that. All right. It does not say people shall have a right to assemble, to express views on other people's property. It just doesn't say it. It says they shall have a right to assemble if they're peaceable. But it doesn't say how far you can go in using other people's property.
You mean even government property? But they,
well, certainly, that's not theirs.
You can't assemble in midair.
That's not theirs.
Or city property.
Well, whose is it? Is government property?
Belongs to the government
property?
as a whole. Just exactly as a corporation's property belongs to the corporation as a whole. And just as an individual owns it. Now, the government would be in a very bad fix, I think, if the Constitution provided that the Congress was without power to keep people from coming into the Library of Congress and spending the day there demonstrating or singing because they wanted to protest the government. I don't think it could.
But
they've got a right to talk where they have a right to be under valid laws.
Mr. Justice, on another very controversial case, the obscenity case in which Mr. Ginsburg was sent to jail by the lower courts and the majority upheld his being sent to jail, you were in the minority. Do you think that there are any times at all when obscenity can be restricted, prohibited, and not come into conflict with the freedom of press guarantee, freedom of speech guarantee in the Constitution?
I've said they couldn't. Of course, I understand that pornography sounds bad. It really sounds bad. But I never have seen anybody who can say what it is. Nobody. Now, some people say it's way over there, and some people say it's way over here. If the idea is to keep people from learning about the facts of life as between the sexes, that's a vain task. So it's a vain task. How in the world can you keep people from learning who mix with others out on the street and around in the various places? They're going to learn, but that's not the reason I take that view. The reason I take the view is that it's an expression of opinion. It refers to one of the strongest urges in the human race, something that people have not failed to talk about, and they will not fail to talk about. People go have organizations and write in letters and say, you're letting my children suffer. There's plenty of argument for the idea that they ought to take care of their children and warn them against things themselves. rather than trying to pass a law. And it's an ambiguous statement. Obscenity is wholly ambiguous. It means one thing to you, and another thing to you, and another thing to these, another thing to me. I don't like it. I don't use it. But I never have. I've always detested it. But that's no reason, I think, that it's not speech on an important subject. Let them talk.
There's an interesting aspect to your position on the obscenity case in that you refused yourself even to examine the evidence, as it were.
That's not peculiar. Why should it be peculiar?
Well, one would think that a judge should examine the evidence.
Why should he, if he doesn't think there is such a thing? Why should I go and look at those things? And I don't look at them. But why should I go and look at them when it doesn't make any difference what the talk is or what it is? I don't think it violates any law. Only those will look at them who think they are invested with the godlike power of looking at it and tell what's obscene. What's obscene enough so they'll let the people see it. I don't feel that way.
Mr. Justice, right now, so much of the public clamor about the court is based on this notion that its decisions have somehow restricted police and aided criminals because of various decisions about a man's rights. How do you look at all that argument?
Well, the court didn't do it.
The court did not do it.
No, the Constitution makers did it. They were the ones that put in no man should be compelled to convict himself. They were the ones that put in every one of these amendments. It's not, they are complaining about the Constitution. They don't know it, or its interpretation. And of course, I don't see how anybody could deny that the Constitution says absolutely, and in words that nobody can deny, in the Fifth Amendment, that no person shall be compelled to be, in a criminal case, to be a witness against himself. And so when they say the court did it, that's just a little off. The Constitution did it.
Well, Mr. Justice, do you think that those decisions have made it more difficult for the police to combat crime?
Certainly. Why shouldn't they? What were they written for? Why did they write the Bill of Rights? They practically all relate to the way cases shall be tried. And practically all of them make it more difficult to convict people of crime. What about guaranteeing a man a right to a lawyer? Of course that makes it more difficult to convict him. What about saying he shall not be compelled to be a witness against himself? That makes it more difficult to convict him. What about no such unreasonable search or seizure shall be made? That makes it more difficult. They were written to make it more difficult. And what the court does is to try to follow what they wrote and say that you got to try people in this way. Why did they want a jury? They wanted it so they wouldn't be subjected to one judge who might hang them or convict them for political crime or something of that kind. And so they had juries, and they said the same thing about an indictment. That's what they put it in for. They were, every one, intended to make it more difficult before the doors of a prison closed on a man because of his trial.
You're all for that?
Yes, I'm for it. I'm for it. I'm for a Bill of Rights, and I'm not saying now that I would write every one in the exact language they've written them, but I'll try to enforce them in the exact language they were written.
Why, as a man who's read a lot of history, lived a long time, watched this country closely, why do you think we have this great rise in crime and general irresponsibility and public disorder? What has happened to people? Is it something really serious?
Well, that assumes a premise that I'm not sure is correct. This country's always been called a country of violence.
That's true.
Right after it was organized, they had a whiskey rebellion up in Pennsylvania. George Washington had to send the army up there to stop it. Nothing new about crime. Now, it's true, different types of crime are increased from time to time or decreased. That's not saying we should have it, because I think the purpose of an organized government with a constitution is hoping that the people will do just what they said they would, what this Constitution was written for. I think the greatest thing our people accomplished was to discover for the first time that you had come nearer having boundaries marked if they had a Constitution. And it's for that reason that I can't join the people who want to make it, the boundaries, more flexible and more vulnerable.
Justice Black, I think it's true to say that more of your dissents have later become the majority opinion in the law of the land than is true of any other Supreme Court justice ever. What's the most important of those dissents that later became law in your mind now?
Which one had the most consequences?
Yes.
Adamson against California. That's the case where I asserted at full length for the first time my belief that the passage of the 14th Amendment made the Bill of Rights applicable to the states. Well, I stated there that I thought the due process clause meant the case should be tried according to the law of the land, clear laws, as written, unambiguously, before a case of controversy came up. And then in the Chambers case, I had stated my concept of the due process, what it actually accomplished, according to my meaning. And that has been utilized a great many times. That statement, which I closed, I stated, and the people here were familiar with the fact that many people had been convicted without following the law, and that our people knew it. Some of the best had been crucified on crosses. Others had been hung. Others had been executed in various manners. But the purpose was to see that nobody in the future should be convicted except under the law of the land, as it was already written. And here was the closing part of what I thought about due process. I still think it. And it's probably the reason that I made the statement earlier that I thought we had the best Constitution in the world, and if we would follow it, it'd be all right. No higher duty, no more solemn responsibility rests upon this court than that of translating into living law and maintaining this constitutional shield deliberately planned and inscribed for the benefit of every human being subject to our Constitution of whatever race, creed, or persuasion. That was my idea then. It's my idea now of due process of law, not a natural law. But they knew about these things and they wanted to stop them. And there it is. And I think if it's enforced that way, this can be, and was bound to be, the best Constitution in the world.
Mr. Justice, I think it may be true to say that there are just two written documents in history that have really governed the great people for a long period. One, the Principate of the Emperor Augustus, and the American Constitution. Maybe there's others I can't think of, but if you could put it briefly, how does one explain the longevity of this document of ours?
Well, I would explain it just what I said, and I hope it doesn't prove I'm a complete chauvinist. I think when those men met in Philadelphia, they had behind them knowledge of a long series of oppressions in Europe. They knew about people getting their tongue torn out, their ears clipped off, having to fight. I think they wanted to get away from that. I think England had gradually moved towards an aspiration for complete equality of treatment of everybody. They had moved a long way. And at that time, I would say that it was the best government in the world before ours. I think our people came over here and they wrote this Constitution. And it is, to me, the best document that has ever been written to control the government. It's not perfect. I think there are parts of it could well be changed. But I think you can well wait about rushing to change things too quickly that are settled habits of the people of the country and settled part of the governmental policies and institutions. You can't do it all in a week. Anybody that thinks that all can be done in a week is wrong. Can't be done. You have the rules set out, and I think that if this government lives permanently, it'll be because the people stick to a government like the one we created. Government of the people. It's intended to be a government of the people, by the people, and for the people. It's failed at various times and in various localities. But it's done mighty well compared with the other nations of the world. It's certainly better than the empire Augustus had. I think this country has lived because of its constitution and its laws and its ideals of liberty and equality and freedom. I think every time we take a move in that regard, and to make it what they said, to improve the public tranquility under law, that it moves another step towards lasting a longer time.
Thank you, Mr. Justice.
Thank you, Mr. Justice.